What is a debt collection lawsuit? In a lawsuit, there are two sides. If someone files a lawsuit, they are called the plaintiff. The person being sued is called the defendant. Often, companies hire lawyers to sue people to collect a consumer debt, such as a medical debt or an unpaid credit card bill. Some debt collection lawsuits are filed by the company the defendant used to make payments to, but many are filed by companies who buy old debts. If you do not recognize the name of the company suing you, you may be being sued by a debt collection company. Many times, the person being sued, the defendant, does not have an attorney. If you are being sued in a debt collection lawsuit and you do not have an attorney, this video is for you. This video will show the steps you need to take to try and reach an agreement with the company that is suing you, also known as settling the lawsuit. One important point: this is not for small claims. This video is not for small claims lawsuits. Small claims court has different rules and a different process. If you have questions about a small claims lawsuit, you should try contacting your local small claims advisor for information. You do not have to settle your lawsuit. Settling is one of several ways to resolve a court case. Instead of settling, you can fight a lawsuit by asserting your defenses at trial, or you can consider filing bankruptcy to discharge the debt. Regardless of what you decide to do, you keep your options open by filing an answer with the court. If you do not file any response with the court by the deadline, the other side can automatically win by asking the court to enter a judgment against you. A judgment is collectible through the court and can be used to garnish 25% of your paycheck or take money from your bank account. If you have not decided what to do yet, and even if you are pretty sure you want to settle, it is generally best to file a timely answer with the court. Your answer is due within 30 or 40 days of getting served with the lawsuit. Not having an attorney. We know that it can be intimidating to be sued and to not have a lawyer represent you. It is even more intimidating if the other side has a lawyer. Even so, it is often possible to resolve a lawsuit with a settlement agreement by talking to the lawyers on the other side. Trial. Most lawsuits do not end up in a trial before a judge. In fact, many studies have found that around 95% of cases settle before going to trial. This is in part because a trial is expensive for both sides, and only one side can come out the winner. You preserve your rights and negotiating power for settlement by filing an answer with the court. Remember, if you do not file an answer, then the other side can automatically win by asking the court to enter a default judgment against you. Negotiated resolution. If you have been sued by a company to collect a debt, you may be able to negotiate a settlement of your case before your trial date, or even on your trial date in the courthouse. A settlement agreement resolves the case without the entry of a judgment against you. If you have decided that settlement is your best option, this video will explain how to prepare for settlement negotiations and how to protect yourself to make sure that an agreement you reach is fair and enforceable. Remember that the lawyer for the other side does not represent you. You do not have to agree with their opinion of the case. Read closely to make sure that the agreement you reach is one that works for your budget and has terms that you understand. Timeline. First, it is important to have an understanding of the timeline of your case. It is possible to negotiate a settlement at any point in your case, as long as a default judgment has not been entered. Your bargaining position will change depending on where you are in the lawsuit. If you are interested in settling your case at the beginning of a lawsuit, you may end up paying more to settle than if you settle closer to the day of trial. Why is this? At the very start of a lawsuit, a debt collector will know that you may be nervous about the lawsuit process, especially if this is your first time being sued in court. To settle a case when you first learn about it may end up being a trade-off in which you pay more to the other side to not have to file any papers with the court or deal with the court process. If you respond to the lawsuit by filing an answer with the court, then no one automatically wins the case and you have more time to negotiate a settlement. Your bargaining position also improves by filing a response to the lawsuit. Depending on how busy the courts are, it may be many months before a case is scheduled for trial. During any of these months, you may attempt to negotiate a settlement. How do you prepare to negotiate a settlement of your lawsuit? It is important to organize your papers, all documents you have received from the court, the lawyers for the plaintiff, and any letters or other information in writing from the debt collector. You should also make a plan to figure out what you can afford to pay. First, make a list of your monthly income and expenses and determine what you can afford each month to pay on this lawsuit. You can pay in one lump sum, which may get a better discount, or you can pay in monthly payments. Second, make a plan. Before you call, email, or write the lawyer for the other side, you should know what you can afford in payments and in one lump sum. Accomplish this by writing down your plan for negotiation. Write down your bottom line, which is the absolute most you can afford to pay. Above that, write your opening offer, which should be about 50% of your bottom line. Figure out where you would like to end up in the middle and make a decision about when you want to stop negotiating if you do not reach that place in the first call. Many settlements require more than one conversation before the two sides reach an agreement. Contacting the other side's lawyer. Try to reach the lawyer for the other side. You can look up the lawyer's name and number on the top of the court papers. You can also look up the lawyer's name on the calbar.ca.gov website to get his or her phone number. When you call the number, explain that you're interested in settling your case. Ask to speak with someone who has the authority to settle the case. Starting negotiations. Open the conversation by asking what the other side would take to resolve the case in one lump sum or in payments. This will give you an idea of how far apart you and the other side are. Make notes during your phone call and remember your bottom line and your goal. If you do not agree with the opening offer, you can explain any hardship that you have experienced or reasons that you cannot pay that amount. You can then counteroffer with your opening amount. What to expect? The lawyer or negotiator for the other side will either agree to your offer, will propose another counteroffer, or will say that they need to ask their client. If you do not agree with the counteroffer, it is okay to say thank you and explain that you are unable to reach an agreement on these terms today. It is okay to hang up the phone and call back another day. Reaching an agreement. An agreement in writing to resolve a lawsuit may be called a settlement agreement, a stipulation, or a release of claims. The agreement should say how much you agree to pay and what happens to the court case. Will the case be dismissed after a single payment, or will you need to make payments for a few months before the case is resolved? The purpose of a settlement agreement is generally to avoid a judgment, so you should object if the other side asks you to agree to a judgment, which is called a stipulated entry of judgment. Instead, you can propose that a notice of settlement be filed with the court and that the case be dismissed after you finish paying. Asking for the agreement in writing. If you reach an agreement on a number, in payments, or a lump sum, ask for a copy of the agreement in writing. You can receive a copy of the settlement agreement in the mail or by email. Review the terms to make sure that the amount is the same you agreed to pay. Make sure that you are not agreeing to both pay and have an entry of judgment against you. Check to make sure that there is an address for payment or a way to make the payment online. Make a note on your calendar of the due date and be sure that the payment is in the mail at least 5 days before the due date. Make sure that you understand the consequences of missing a payment. Many settlement agreements say that there will be a judgment entered if payments are not received on time. Case dismissed with or without prejudice. Cases may be dismissed with prejudice or without prejudice. Your settlement agreement should say that the case will be dismissed with prejudice upon all payments. This means that no one can ever try to collect from you again for this debt. Trying again if agreement not reached. Many settlement agreements take a few tries. If you wait until closer to the trial date, you may be more likely to reach an agreement. Settling in the courthouse. If you filed an answer and have been unable to reach an agreement, when you go to court for the trial, you may still be able to reach an agreement before the time for your trial. The judge may ask if you have tried to reach a settlement and give you a chance to talk to the lawyer for the other side in the hallway. Even on the day of trial, a settlement in advance of trial will be better than a judgment against you. Paying your settlement. Remember to make your settlement payments on time. Once the settlement agreement is paid in full, the other side's lawyers will need to dismiss the case. You should receive a copy of the dismissal with prejudice in the mail once the settlement is paid in full. If you do not, call up the lawyers and ask for a copy of the dismissal. If the lawyers do not send you a copy, you may also ask the Court Records Department for a copy of the dismissal. Keep a copy of the settlement agreement, your payment receipts, and the dismissal for your records to prove that the case was resolved for less than the full amount. Now you know how to settle your debt collection lawsuit.